All right, everyone, welcome to Criminal Forensic Assessment. We have a special guest lecturer today. She is an expert in the forensic world. Today we have Dr. Mandy Saar, who is going to be lecturing for us today. Thank you so much for being here, Dr. Saar. I'll turn it over to you.
Hi, everyone. I'm glad to be with you today. And our lecture today is going to be on criminal responsibility. So I want to start with an example that I'll try to carry throughout the lecture. So Mr. Jones is driving his car. He strikes and kills Mr. Smith. Did he commit a crime? It depends. Did he deliberately aim his car at Mr. Smith? Were they involved in an argument right before Mr. Smith was hit? Had Mr. Jones ever threatened to harm Mr. Smith? Let's say they were strangers. Was Mr. Jones intoxicated and hit Mr. Smith because he was driving erratically and did not see him? Was he on his cell phone and distracted when he hit Mr. Smith? Was he driving carefully and he had to swerve around an oncoming truck and he inadvertently hit Mr. Smith? The differences in all these scenarios revolve around the mental state of Mr. Jones and his intentions. Did Mr. Jones have a guilty mind? So at the heart of the insanity defense and criminal responsibility is something called mens rea, guilty mind. Was it premeditated? If Mr. Jones was intoxicated or negligent in his driving, he would probably be convicted of a lesser crime like manslaughter. If it was an accident beyond his control, he probably would not be found guilty of any crime. What if Mr. Jones claims that his lack of a guilty mind is due to a mental impairment? How will we know if his disorder is severe enough? And how do we determine what functional impairments are relevant to Mr. Jones' culpability for his crime? And how do we even know his disorder is genuine? So that's what we're going to talk about today. And we're going to start with way back in history when the insanity defense first came about. So about 2,000 years ago in the Hebrew culture, we had something called Mishnah. And this included young children and people who today would be called mentally ill or intellectually disabled. So a very long time ago, the idea of the insanity defense, or that people who did not have the mental capacity to know they created a crime, that's been around for a long time, the idea that they would not be held liable. Way back in Anglo-Saxon times, people were referred to as lunatics or idiots. These were just common sense terms, lay people terms. No expert opinion was required. So the idea that we need an expert to tell us whether or not someone meets criteria to be insane is a new concept. But the concept of being insane and not responsible is an old concept. In 18th century England, they had something called the wild beast standard. And this required a person to basically be like an infant. They didn't know anything at all. They didn't know what they were doing. They were, totally mentally deprived. So across history and even today, there are different variations or standards in what it means to have insanity and have it severe enough that you're not responsible. But the idea of the insanity defense has been around a long time. And despite public opinion, as much as we see it on TV, the insanity defense is not often employed, and it's often unsuccessful. So it's used about 0.9% of the time, about 9 in every 1,000 cases, and only about 25% of those insanity defenses are successful, and even less than 25% when a violent crime is involved. And then if we examine our prison system, we'll see that the rates of mental health disorders in prison exceed that of the non-incarcerated population. So about 50% of all state and federal prisoners have a mental illness, And over 60% of local jail inmates have a mental illness. And about 25 to 40% of Americans who have a mental illness will be incarcerated at some point in their lifetime. Now, every state has its own standard for insanity, and so does the federal system. So your job as the forensic evaluator, one of your most important jobs, is to know the laws and rules in any jurisdiction that you practice in. You should never practice in a jurisdiction without knowing the standard that that jurisdiction is going by for the insanity defense. Now, the insanity defense is different from competence to stand trial. You might at some point get asked to do a competency evaluation, and that's looking at whether or not the defendant has the current capacity right now to participate in a trial, participate in their defense with their attorney. But insanity is concerned with the defendant's past mental status at the time of the alleged offense, at the time of the crime. So that's even more difficult to determine. We're being asked to help determine what was the defendant's mental state then when they committed the crime. So the focus in the insanity defense is on the intent of their actions. Did they have a guilty mind? So sanity has also a subjective moral component. So there are two prongs to the insanity defense. There's the cognitive prong. Did they know what they were doing? Did they know right from wrong? And then there's the moral component. Did they understand that it was wrong? So insanity is always going to focus on the mental state of the defendant at the time they committed the offense. And usually the defendant is going to admit that they committed a guilty act. Guilty act is actus reus. They're going to admit that usually. And then the court is going to decide if they were sane or insane. Now that's another important part. Notice I said the court is going to decide. You as the forensic evaluator are not going to decide if the client is sane or insane. You're going to put together all the evidence. You're going to collect all the data. You're going to write a report, and then the court will decide based on that. And you can give an opinion, which you back up out of the evidence, but ultimately the court will decide if the client is sane or insane, the defendant. So let's talk some more about the laws that are the underpinning of the insanity defense. So one of them is the McNaughton standard, which came about in England in 1843. And that's the modern underpinning for most of the insanity defense standards in the US today. So the burden of proof in the insanity defense rests on the defendant. And in most jurisdictions, the defendant has to bring forth that defense. So the defense attorney has to say, my client wants to plead not guilty by reason of insanity, or my client wants to plead guilty but mentally ill. And we'll talk about what the difference is between those. And so then the burden is on the defendant to prove that at the time they committed the act, that due to a disease of the mind or a mental defect, they did not know that the act was wrong and they didn't know what they were doing. And so that's the McNaughton standard. To meet the McNaughton standard, they don't know the act is wrong and they don't know what they're doing. So this is basically a right versus wrong test, and it focuses only on that cognitive prong, not on the volitional prong. So what the volitional prong is talking about is, how could we determine if the client, if the defendant could resist an impulse or not? Let's say that Mr. Jones and Mr. Smith from before had an argument the day before, and Mr. Jones had schizophrenia, and he thought Mr. Smith was out to get him, and he heard a voice telling him to run Mr. Smith over with the car. How do we know whether or not Mr. Smith could have resisted that impulse and the command hallucination to run Mr. Smith over with the car? So by the McNaughton standard, we would only be concerned with whether or not Mr. Jones knew that it was wrong to run Mr. Smith over with the car. But when we add in the volitional prong, then we have to also question, did Mr. Jones have the ability to resist the urge due to his schizophrenia to run Mr. Smith over with the car? So that takes us to another law, the Durham rule. And this came down from the Federal Court of Appeals in 1954 in the District of Columbia. And then we began to talk about whether or not the act was the product of a mental illness. So if the criminal behavior is the product of a mental disease or defect, then the defendant could be found not guilty by reason of insanity. So once the Durham rule came about, this really broadened out the McNaughton standard and gave forensic experts way more leeway to provide the courts with relevant mental health testimony. Because if the only question is whether or not the person knew right from wrong, then we don't get to delve into their mental health very much. We may test their IQ and, intellectually, were they capable, but we can't delve into their whole, everything that makes them mental health wise. But the Durham rule gives us way more digging capacity. And we're going to talk about, what kinds of information to dig for and how we go about excavating all the information and putting all that together. Unfortunately, though, the Durham rule did not really result in clearer testimony from mental health professionals, because there still was not a lot of guidance from the legal perspective about what a mental disease meant. What fits the bill for a mental disease? Does that mean we go by the DSM? Does that mean we just take an expert's opinion? Because clinical assessment is very different from legal determinations. So the Durham rule broadened out what we could look at and what we could testify about, but really didn't give very clear guidance. So in 1962, there was another case, McDonald versus the US. And in this case, it clarified a little bit more. So in this case, any abnormal condition of the mind that substantially affects mental or emotional processes and substantially impairs behavioral controls. So they still did not clarify how to determine if the criminal behavior was a product of the symptoms of the mental illness. How do we determine if Mr. Jones really hit Mr. Smith with the car because he had a command hallucination that told him to do so, as opposed to maybe Mr. Jones is just an aggressive jerk, and that's his personality every day to everybody. Or maybe it's the situation. Maybe when they had an argument, Mr. Smith threatened him, and now he feels that he must retaliate for his safety. So the McDonald versus US case gave us a little more clarity about how to determine if the criminal behavior, it gave us a little more clarity that we need to determine if the criminal behavior is the product of the symptoms of the mental illness. It didn't exactly tell us how to do that. So at that time frame, in the 1950s, 60s, there's really not a lot of clarity for us as forensic experts like we have today. But in 1972, the Supreme Court adopted something called the American Law Institute standard. And this gave us a lot more clarity. So the American Law Institute standard requires the defendant to lack substantial capacity. They must have a significant impairment, not a total lack of ability like the wild beast standard back in England, but a significant impairment. And they have to, they appreciate that their conduct was wrong, but they don't fully understand it. They can't conform their conduct to the requirements of the law. So they are aware of the significance of the criminal act. Do they know? Do they know what's wrong? So the American Law Institute standard covers the cognitive prong and the volitional prong, both of those. And so either one of those, the person can be considered insane. So not guilty by reason of insanity, that means the person gets an acquittal, right? And I guess in society, some people would feel like, oh, well, they got away with it. They didn't have any punishment. Nothing happened to them. But the research shows that's not true. Most defendants who are found not guilty by reason of insanity actually spend more time in a forensic hospital than they would have spent in jail if they were convicted of the crime. So they typically go to a forensic psychiatric hospital until they're determined to no longer be mentally ill or no longer be dangerous to themselves or society. And there's no time frame for how long that could be. It's not like when a client is suicidal in the clinical world and they get a 72-hour hold. The person that's found not guilty by reason of insanity, they're going there for a long time. And so research shows they typically spend more time. Then there's guilty but mentally ill. Now that is a criminal conviction, guilty but mentally ill. And that's most common when the defendant lacks the appreciation of wrongness. They don't really understand the crime was wrong, or they lack the understanding of the consequences of their actions. So they can be found guilty but mentally ill, and that's a criminal conviction. But instead of going to jail, they're going to a forensic psychiatric hospital. So how long can they stay? They can stay a very long time. And is that constitutional? What's the law about that? So the Supreme Court decided that there's not a correlation between the length of the criminal sentence that someone would have received if they were convicted and the length of confinement that's required for treatment and for protection for society and for themselves. In other words, the Supreme Court decided that it doesn't matter if they stay in the psychiatric hospital longer than they would have spent incarcerated in jail. That people who are acquitted under the not guilty by reason of insanity verdict can be submitted to more stringent standards for release, even when they leave the hospital, than people who are criminally convicted. So the goal is to treat their mental illness and protect them from themselves and protect society from them and their potential dangerousness. Whereas for a criminal, the length of their sentence is based on retribution, deterrence, and rehabilitation. So it's a very different model and things that go into it. And did you know that there are states that have no insanity defense at all? That you can't even bring an insanity defense in those states. And the Supreme Court has not really addressed the constitutionality of that. So one famous case regarding this is Clark versus Arizona. It came about in 2006. And the Supreme Court ruled in that case that there was no constitutional requirement for a jurisdiction to include any specific language as part of the insanity defense. So there's nothing that says that a state has to use either the cognitive prong or the volitional prong. They can have no insanity defense option at all. And in that same case, the Supreme Court upheld a very restrictive approach towards expert mental health testimony related to whether or not the defendant has a guilty mind. So what was this case about? It's actually pretty interesting. So Mr. Clark, he had an expert psychiatrist that gave mental health testimony that he had paranoid schizophrenia. And in his paranoid schizophrenic state of mind, he believed that a police officer was actually an alien. So he shot and killed the police officer in the context of his paranoid delusions that the officer was an alien. And in that context, he did not understand that his actions were wrong. He actually thought that he was protecting himself and other people by killing an alien. So the opposing expert that was called by the prosecution argued that he was aware that his actions were wrong. And the judge concluded that Mr. Clark's paranoid schizophrenia did not distort his perception of reality severely enough that he didn't know his actions were wrong. Also in this case, Clark argued that he did not intend to kill the officer, but he was not allowed to present expert testimony on that. He was only allowed to present lay testimony. So when he did his appeal, he claimed that that was unconstitutional. It was unconstitutional to not allow evidence about the impact of his schizophrenia on his ability to form the intent to kill the officer. And the Supreme Court ruled against him in that case. And they said that expert testimony on mental disorders might confuse the jury about the ability of the defendant to form intent, and that the state of Arizona had the right to exclude expert mental health testimony. So now in Arizona, the testimony about the ability to form an intent is the person cognitively capable of forming an intent. That's allowed, but not by an expert. It's restricted to lay testimony. Very interesting, right? So what about more recent cases? Okay, so a more recent case is Kaler versus Kansas in 2020. And in this case, the Supreme Court ruled that the 8th and the 14th Amendments of the Constitution do not require states to adopt the insanity defense in criminal cases based on the defendant's ability to recognize right from wrong. So based on the McNaughton standard, the ability to recognize right or wrong, the Supreme Court ruled that states do not have to adopt the insanity defense. And the court held that due process, your constitutional right to a trial, speedy trial, and due process through the court system does not require Kansas to adopt an insanity test based on moral capacity either, the volitional prong. So a defendant cannot bring forth the insanity defense in the state of Kansas, just like they can't in Arizona. And there are currently 4 states that follow this approach. So, like I told you before, the burden of proof for the insanity defense is always on the defendant, and the standard of proof varies by jurisdiction. So one of the most important things for you as the forensic examiner is to know all the laws in your jurisdiction, because you should be aware of the burden of proof in the jurisdiction you practice in. So it could be based on the preponderance of evidence. Is it more likely than not that Mr. Jones ran over Mr. Smith because he had a command hallucination telling him to do so? Is there clear and convincing evidence? Do we have, people that were in his life that knew that he experienced command hallucinations? Does he have mental health records documenting his paranoid schizophrenia and his command hallucinations? What is there really clear evidence, clear and convincing evidence? Beyond a reasonable doubt may be the standard of proof in your jurisdiction. Or the burden. So there's many different options for the standard of proof, and you have to know that for your jurisdiction. Now, when you write your report, you should not state an opinion on whether or not the burden of proof has been met. It's not your job to make that decision. That's the responsibility of the judge or the jury. So what should you do? You should comment on the strength of the data. And we're going to talk about how to gather the data, what kinds of data to gather, how to analyze it. So what you're commenting on is the strength of the data that forms the basis of your opinion as a forensic expert, and the degree of confidence that you have in the opinion that you're offering to the court. But you're not going to make the actual decision about whether or not the burden of proof is met or about whether or not the defendant is sane or insane. That is not part of your job. Your job is to provide the court with a thorough and accurate assessment of the defendant's mental status, focusing on their functional abilities relevant to the legal standard and the jurisdiction you're practicing in. So, an individual with a certain diagnosis, let's say Mr. Jones with his paranoid schizophrenia, and his clinical presentation with command hallucinations, he may be considered sane in your jurisdiction, and in mine, he might not. So, insanity is always a moral and a legal decision, not a clinical one. And it depends on the jurisdiction. Now, let's talk a little more about guilty but mentally ill. So, guilty but mentally ill allows the jury to recognize that the defendant suffers from a mental illness without them having to actually acquit the defendant due to his insanity. And most guilty but mentally ill verdicts are arrived at by plea deals, not jury trials. And so this suggests that defendants are often convinced to accept a plea bargain to be found mentally ill, guilty but mentally ill. Maybe they think that it means they're going to get less responsibility or punishment, but it really doesn't mean that, because remember, they might spend more time in the psych hospital than they would have spent in jail. Sometimes, as the forensic evaluator, you will be asked to determine if someone is guilty but mentally ill. And when you're asked that, you're simply being asked if the person had a mental disorder at the time of the alleged offense. You're not being asked its effect on them. So, like for Mr. Jones, the question would be, did he have paranoid schizophrenia when he hit Mr. Smith with the car? Not anything about the volitional prong at all, right? So in some jurisdictions, guilty but mentally ill may also include an assessment of the defendant's mental state at the time of their sentencing. So when you're doing your evaluation, you always have to clarify exactly what it is you're supposed to be assessing. Okay, so what if someone is competently choosing not to use the insanity defense? What if Mr. Jones knows he has paranoid schizophrenia and he knows that a command hallucination he thinks made him run over Mr. Smith, but he doesn't want to use the insanity defense because it might result in him spending a very long time in the psych hospital, or it might mean that when he's released from the hospital, he still has a lot of conditions he has to comply with. And then there's the stigma of having been in the psych hospital and everyone knowing you have paranoid schizophrenia, right? So maybe he doesn't want to use that defense. Can the judge make him? And the answer is, if he's competent and he's making the decision voluntarily and intelligently, then no, we can't make him choose the insanity defense, even if the judge thinks it's better for him. But if he's not doing it voluntarily and intelligently, and he's not competent, then yes, the judge can make him use the insanity defense. So there are all these little details like this that you need to be aware of when you practice, because you have to know the clinical side and then you have to know all the laws too. So the forensic evaluator might conduct a criminal responsibility evaluation prior to the decision about whether or not to impose the insanity defense. The judge may say, I want a forensic evaluation to determine if this client, this defendant, is competent. And can they make this decision? And then your job will be to obtain all the relevant data and provide the clinical data and an analysis of that defendant's functioning and mental status and capacity to be able to do that. So sometimes you're going to be appointed by the court, and sometimes you're going to be retained by the prosecution, and sometimes you'll be retained by the defense attorney. And who retains you and who orders you to do the evaluation feeds into your report, what you're going to write, who you're going to give the report to after you write it, and some of what you put in it. So who gives you the referral is very important. Your client, though, is always the court. The court's the client. So in the clinical world, the client's the client, right? In the clinical world, the defendant would be the client. But in the forensic world, the client is the court. So you must understand at the outset of any forensic evaluation you do, who is going to receive your report and who can you communicate with during this process. So you will obtain detailed information about the defendant's alleged version of the crime. So what does Mr. Jones have to say about hitting Mr. Smith with his car and killing him? What's his version? How did it happen? And you might, in the course of that, obtain some information that sounds like Mr. Jones is confessing to deliberately hitting Mr. Smith with the car, right? And then let's say you're working for the defense attorney of Mr. Jones, but let's say that the prosecution gets a hold of your report because you release it to them too. And then they may be able to use your report to strategize for how they're going to present their case in court to convict Mr. Jones. Or they may be able to use information in your report to uncover other evidence that could help them convict Mr. Jones. So the actual information you obtain, it can't be used as evidence of guilt, but it could cause the prosecution to be able to convict him by being able to strategize their case or by uncovering other evidence that they would not otherwise have uncovered or obtained. So it's really important to know, even though the client is always the court, it's really important to know who you are working for, who retained you, and where does your report go when you complete your report. Because also the procedures for submitting your report vary across jurisdictions. Sometimes you're going to send it directly to the court. Sometimes it will be to the defense attorney and the prosecution. And sometimes it may not be shared with the prosecution at all unless the defense attorney chooses to assert the insanity defense. So sometimes you're going to be doing an evaluation, but you don't even know yet if the defense attorney is going to put forth an insanity defense for the defendant. So you have to be knowledgeable about all the laws and procedures in your jurisdiction about releasing your report and communicating your data. So one of the first things you have to do is clarify all the laws about disseminating the information. And I always do that with the attorney that hired me. If I have any questions at all, I go to the legal code, I read it myself, and then I discuss it with the attorney that hired me. Usually I'm hired by defense attorneys. So that's normally when I'm, retained by the defense, most of the information that I obtain is protected by attorney-client privilege when I'm hired by the defense attorney. So I will be providing information back only to the defense attorney, and then they will choose whether or not to release that report to the prosecution. They will choose whether or not to call me as an expert to testify. But it doesn't work that way in every jurisdiction because every state can develop its own rules. And it's your job to know those rules at the outset of the evaluation. Now, after you collect all your data, what you're going to do is integrate all that data into a forensic formulation about the functional and mental status of the defendant at the time that they committed the alleged offense. And the defendant must suffer from a severe disorder at the time of the defense. And most of the time, this is going to be a psychotic disorder, like Mr. Jones and his paranoid schizophrenia. And sometimes it might be a major affective disorder. So it could be that Mr. Jones had bipolar disorder and he had psychotic features and he just happened to be hearing command hallucinations at that time. So that's kind of the severity level of mental illness that you're typically going to see in these cases. And it must be demonstrated how the disorder is severe enough to impair the defendant's ability to rationally perceive or understand the circumstances surrounding the alleged offense or to make rational choices. Now, another less common one that I've seen is PTSD. So, let's say someone is experiencing a flashback of their original trauma. And it's so severe that they believe that they're actually back in their original trauma again, and it's happening all over. So they're not in the present reality. They're in the original trauma. So what would have to happen then is it would have to be demonstrated that the defendant was experiencing acute symptoms of they were having that flashback at the time that they committed the offense, and it impaired their ability to rationally perceive the circumstances around them when they committed the crime. All right, so when you do your evaluation, should you put a diagnosis in the report? Should you give the client, the defendant, a DSM diagnosis? Well, the APA says yes, they recommend that. The APA recommends that because diagnostic categories are useful to help you gather, organize, and evaluate the data. It's like a sorting process, right? So like the same sorting process that you use in the clinical world for differential diagnosis, these symptoms go in this diagnostic category. We can use that same sorting process as forensic evaluators, and it will help us increase the credibility of our assessment, and it will help us determine if the defendant's disorder is included in our jurisdiction's legal standards. So one thing we want to do is consider the pattern of symptoms that are typical in that diagnostic category. So for Mr. Jones, are his symptoms of paranoid schizophrenia credible? Do most paranoid schizophrenics have command hallucinations? Could he be malingering them? Is this something he can fake? Could he be exaggerating them? Maybe he doesn't have the hallucinations all the time. Maybe he wasn't having them when he hit Mr. Smith with the car. So we want to ask ourselves, does Mr. Jones display any other symptoms of paranoid schizophrenia? Does he have flat affect? Does he have avolition? So putting his hallucinations into a diagnostic category helps us as the evaluator to assess the validity and the significance of those symptoms. And if we know that he's been hospitalized 5 times in the past, and that he's already been diagnosed with paranoid schizophrenia. And then we uncover more symptoms that Mr. Jones has that are consistent with that diagnosis. Then the credibility of our assessment is enhanced by uncovering that information. And so the kinds of questions we're going to ask Mr. Jones and the kind of information we're going to gather about him is influenced partly by our understanding of the diagnostic category, schizophrenia. What if a client says, I don't have any memory of that. I don't remember the crime at all. Not at all. What would you think diagnostically? Maybe this is signs of dementia. Maybe their memory was impaired by acute intoxication. And now the event just doesn't register for them at all. They have registration amnesia. Maybe they have another cognitive deficit. So the information you get from the defendant about their state of mind at the time of the crime, of the alleged offense, is going to guide your interview. So what about that part of the standard that's the volitional prong? What about that part? That part's a lot more difficult for the forensic evaluator to assess, a lot more difficult. So we're looking at their capacity to make choices, their capacity to delay their impulses. Can Mr. Jones sit back a minute and think about whether or not he should hit Mr. Smith with the car and whether or not he has any other options other than running Mr. Smith over with the car? Does Mr. Jones have any regard and knowledge of the fact that he could be apprehended by the police and there could be a consequence for hitting Mr. Smith with the car? So those three things are going to really help us assess Mr. Jones' degree of volitional control at the time of the alleged offense. At the time he hit Mr. Smith with the car, was he able to make any other choices? Was he able to delay his actions at all? And was he aware that he could be arrested by the police and held accountable and there could be consequences? Now, two more things we might consider is whether it was foreseeable. What was his state of mind in terms of, premeditation? Was it avoidable? Was it the result of a mental disorder, right? So let's talk about Mr. Jones's ability to choose his behavior. Was he capable of perceiving any alternatives to the criminal behavior? Maybe they could have talked it out. Did Mr. Jones believe that the only response to his situation was the specific criminal behavior that he did? Did he consider any alternatives? So we have to ask Mr. Jones that in our interview. And if he did consider alternatives, what were they? And what was the thought process that he went through in his mind when he chose the course of action to hit Mr. Smith with the car? So we have to question him about that. Was he able to engage in any mental deliberation of different alternatives? Or was that impaired and he just acted and hit him with the car in the moment? Did he try to resist at all? Did he try to get the command hallucinations out of his mind? Did he try to resist hitting Mr. Smith with the car? Or was it a goal-directed behavior? Did he think to himself, hey, I need to run him over? So then we want to look at what was the capacity of Mr. Jones to stop the process of running Mr. Smith over with the car. So as the situation presented itself, this opportunity to run Mr. Smith over with the car, why did Mr. Smith do that at that time? Was it really because a command hallucination told him to? Did he sit and wait down the street for Mr. Smith to come out of his house and be in the road? Did he choose the circumstances and the place where he would run him over? Or was it random? And he had been having this command hallucination to harm Mr. Smith, and then he just happened to see him in the road. After he hit Mr. Smith with the car, did Mr. Jones do anything to avoid being detected or apprehended by the police? And how did he react emotionally to having hit Mr. Smith with the car? Did he care? Was he distressed? Did he show any empathy? Did he cry? Was he still angry at Mr. Smith? So we're going to ask him all of these things in our forensic interview. And then the totality of everything, Mr. Jones' self-report, collateral information from other people involved in his case, witnesses that saw him hit Mr. Smith, police officers that arrived to the scene, EMS workers that arrived to the scene, maybe Mr. Jones's family members that know what his typical behavior and demeanor is. All that will come together to be assessed and analyzed by us. And so at the end of the day, can we say that the data and our analysis are consistent with Mr. Jones's claim that his actions were impulsive? He saw Mr. Smith, he had the command hallucination, he hit them. He hit Mr. Smith. And do the data and analysis support that Mr. Jones did not plan this action? Okay, so as the forensic evaluator, I cannot say that Mr. Jones is incapable of premeditating the murder of Mr. Smith with the car. I cannot say that he did not premeditate it or that he's incapable of premeditating it. Did he choose to enter this high-risk situation where he might have difficulty controlling himself? Did Mr. Jones have any way to anticipate that he might lose control? You know, is he aware that he loses control at times, right? And if so, what impact did this awareness have on his behavior? So the loss of control is legally relevant in that I'm not going to offer an opinion on whether or not he meets the criteria for insanity, but I might offer an opinion about whether or not Mr. Jones could have taken some steps to minimize the risk of the crime occurring. Would he have been capable of just staying in the house and not going out in the car? You know? So, you know, Mr. Jones, we gather some information on him. And we find out that he has a very long documented history of paranoid schizophrenia. He's had 5 hospitalizations, but he functions really well when he's on antipsychotic medicine and engaged in therapy. But when he discontinues his medicine, his symptoms re-emerge. And then he has physically assaultive behaviors. He doesn't like the side effects of his medicine, so he stops them frequently. And then he has delusions. And he's committed assaults in the past in reaction to his symptoms. So this was actually a real case that I had. And the evaluation showed that his capacity was impaired. Mr. Jones discontinued his medications. And in this case, the prosecutor argued that he discontinued his medications knowing that doing that could lead to an increase in symptoms and elevate the risk that he would behave violently towards someone. What does that mean for me? For me, I can't say that Mr. Jones does or does not qualify for the volitional prong of the insanity defense. What I have to do in response is provide information about Mr. Jones' state of mind at the time that he discontinued his medicine. And then the court can decide how to apply that information. The judge can decide, based on the information I provide, if he thinks that Mr. Jones was psychiatrically stable at the time he decided to quit taking his medicine, or had he already begun to experience symptoms that impaired his judgment. Okay, let's see what else we want to talk about today. So let's see. I want to make sure that I don't talk to you for too long today. Let's talk a little bit about your competence as the evaluator. So you have to have relevant knowledge and experience before you take a referral. So when you get a referral, one of the first things you're going to do, let's say that Mr. Jones' defense attorney comes to you and he says, hey, can you do a criminal responsibility evaluation for Mr. Jones? You're going to say, what is the specific referral issue? And you're going to think about your role, which I've talked some about, and you can't let your objectivity be colored or compromised by interacting with the defense attorney. So you're going to have to interact with Mr. Jones' defense attorney if he's retaining you, but it's best not to discuss your opinion until your entire evaluation is concluded, because then it minimizes the opportunity for bias to enter your data gathering process and influence your opinion. So if there are any conflicting obligations, you need to think really hard about not taking the case. Let's say that you used to work as a therapist and Mr. Jones was your therapy patient in the past when he was in one of his hospitalizations. Probably shouldn't take his case as a forensic evaluator. Let's say that the defense attorney says, could you be Mr. Jones' forensic evaluator, and could you also work as a consultant for me? I need help with the jury selection for Mr. Jones's trial, or I need help putting together my defense strategy for Mr. Jones. That's a no for me. I'm going to say no, because those two dual relationships of evaluator and consultant are not going to allow me to give Mr. Jones the best forensic evaluation. Okay, you have to be authorized by the court or the attorney to conduct the evaluation, and you have to know the scope of the evaluation. Are we looking for not guilty by reason of insanity? Are we looking for guilty but mentally ill? Are we looking for diminished capacity? Are we looking for extreme emotional disturbance? Do we want to look at whether or not Mr. Jones needs treatment? Who am I going to release the report to? And all that is going to help me determine, when I sit down with Mr. Jones to interview him, what am I going to say to him about the limits of confidentiality for the information he gives me? So I have to know the rules of my jurisdiction. Can the defense attorney be present during the evaluation? Can the evaluation be recorded, right? And if the defense attorney is present, then I have to try to limit his influence on the defendant's responses. And in some jurisdictions, the defense attorney has the right to be present. So you have to know about that rule. Okay. So you're not an advocate for the defendant. That's not your job. And you're not an advocate for the defense attorney. You have to be very neutral and objective. And sometimes this is hard to do, but you have to do it. So you're going to be like a scientist, testing different hypotheses about Mr. Jones' behavior, right? And looking to confirm or disconfirm or corroborate alternative explanations for his behavior. And always remember, Mr. Jones is highly motivated to present information in a manner that's designed to bring about his desired outcome. So if Mr. Jones wants to mount an insanity defense, you can't begin with an assumption that he's going to be honest and forthcoming with you as the evaluator. He might exaggerate his psychopathology. He might minimize any data that suggests that he is rational. He might also decide to minimize his psychopathology because he doesn't want to be institutionalized. So it could go either way. He could either exaggerate his symptoms or underreport his symptoms. So you have to be alert for all of that, all of those possibilities. You also have to be alert for all the other sources of information. Everybody involved in the case could have a vested interest in a particular outcome. The arresting police officer that worked the crime, worked the accident, he may want to see Mr. Jones be convicted. So a witness, there might be a witness that's disposed to exaggerate. There might be another witness that's designed to minimize the event. So even when you're interviewing all the collateral sources, you have to be mindful that not everyone is going to be forthcoming, and people may be coming to the table to speak with you with their own preconceived notions of what they want to happen in the case. So what kind of information are we going to collect? We're going to collect historical information. We want to know all about Mr. Jones' background, anything that could be relevant to allow us to form an opinion about his mental disorder, his paranoid schizophrenia. We want to know his current mental status, anything that could be relevant to what his mental state was at the time of the alleged offense when he ran Mr. Smith over with the car. So historical data is important, like his 5 hospitalizations. Current mental status is important. We want to observe his mental state. We want to talk to anyone that observed his mental state and behavior around and at the time of the alleged offense when he ran Mr. Smith over with the car. And we also want to collect some structured data. Okay, so we're probably going to interview his family, his friends, about how he functioned over periods of time and at the time of the alleged offense. We won't be able to share information about Mr. Jones' current treatment or mental status with his family or friends. We have to explain to his family and friends our role, the purpose of our evaluation, how we will use the information we collect, and that they're not compelled to answer our questions. And we can only use identifiable sources. So in our report, we're going to attribute the data to a specific source. We have to tell where all our data came from. And then we want to reveal documented records. So, I told you Mr. Jones has been in trouble for physical assault before. So we're going to review his criminal record. We're going to review his prior inpatient treatments. We're going to review historical records of substance use. And we're going to use all the background information to formulate relevant questions that we're going to ask Mr. Jones when we interview him, and information that will help us assess the meaning of his answers. We're going to review the specifics of the alleged offense before we sit down with Mr. Jones and get his account directly. And all this is going to form for us an initial impression of the extent to which his version and the version from the police and the prosecution are consistent or contradictory. And all that will guide the further lines of inquiry that we're going to follow. So it's like as we go along, we're following a path. So let's see. So we're going to want to know things about his family of origin, his early history. Is there a family history of mental illness or substance abuse? Did one of his parents have paranoid schizophrenia? How was his home growing up? How was his early adjustment? Does he have a good relationship with his parents and siblings? Is there a history of disruptions in his family attachments? Was he ever physically or sexually abused? Was he exposed to any traumatic events? How did Mr. Jones perform in school? Was he well adjusted socially and behaviorally? Did he make friends in school? Was he placed in special education classes, or did he take regular classes in the general education environment? Was he suspended or expelled from school? Did he have cognitive limitations that were consistent with special education placement? And we want to ask about Mr. Jones' social relationships. Has he ever been married? Does he have friends? Is he a loner? Can he maintain friendships over many years? His employment history. Can he hold a job? A lot of paranoid schizophrenics can't hold a job. How many jobs has he held? How long does he spend at each job? When he loses a job, did he quit or did he get fired? If he got fired, why did he get fired? Has he served in the military? Has he ever had any combat trauma? How did he react to that trauma? Did he have a job at the time that he hit Mr. Smith with the car? And if he did, how was his employment performance? Because all that speaks to his state of mind around the time of the incident. And so we're going to do a really, really deep dive into his mental health history. Did he have a developmental disability as a child? What kind of mental health treatment has he received in the past? What was his initial presentation when he went in the hospital? How did he respond to treatment? What was the course of his illness? Let's see, what else? Medical history. Has he ever had a head injury? Does he have a history of seizures? Has he had a stroke? Has he ever lost consciousness due to a head injury? And if he's had a head injury in the past, was there any evidence of impairment in his cognitive abilities or his mood or his behavior after that injury? And if he's had a head injury in the past, was it close in time, proximity to the alleged offense that he committed? And here's another interesting part of this case. So Mr. Jones says that God told him to hit Mr. Smith with the car, that Mr. Smith deserved to die for his sins. So now that means that it could be relevant, it is relevant for me to find out if Mr. Jones has religious delusions on a regular basis. And does he have any unusual beliefs of a religious nature that might be relevant? And, how delusional are those beliefs? How complex are they? So now I'm going to want to look into all that too. And I would want to find out if Mr. Jones uses any substances. Now, he doesn't use them regularly, but he has used cocaine occasionally and he has used meth occasionally. And so, there is a very high prevalence of substance use among criminal defendants, and it's often comorbid with mental illness. And Mr. Jones has had some periods of homelessness during which he used substances. So that's an important thing for me to know. And so I'm going to have to investigate the relationship between his substance use and the presentation of the symptoms of his paranoid schizophrenia. I want to know how old he was when he first used cocaine. How old was he when he first tried methamphetamines? What's the degree of his usage? Has he ever had treatment for his substance use? Has it affected his ability to hold a job? Has it caused him the loss of his marriage or a loss of custody of his children? Has he engaged in violent or criminal behavior while he was intoxicated with substances? Has he blacked out when he was using substances? Does he have a history of withdrawal effects? Um, all of those things are important. So I need to know if Mr. Jones' psychotic symptoms are independent of his drug use. Has he had those psychotic symptoms when he wasn't using drugs? Are they exacerbated by his substance use? Um, do the psychotic episodes continue past the point of intoxication from the substances? So all of those questions are going to become a whole new area that I really have to delve into really, really in deep depth, lots of depth, to determine if Mr. Jones' mental status was affected by the substances at the time of the alleged offense. And I also want to know, before I interview him, when was the last time he used substances? Because I want to know if his mental status during my interview is a function of substance use. I have to know that too. Okay, so, and I'm also going to interview him about his criminal history. And the goal of all this interviewing and all this collateral data collection, all of this, the goal is for you as the forensic evaluator to reconstruct the defendant, Mr. Jones' state of mind at the time of the alleged offense, at the time that he ran Mr. Smith over with the car. And your job is to come up with a plausible formulation that best fits all the data. So after you collect all the data, you're going to try to reconstruct his state of mind and get to the explanation that best fits the data. Okay, so what if the police officer says that at the last minute, a witness saw Mr. Jones hit the gas pedal and speed up and hit Mr. Smith super hard, and his body flew up in the air and slammed onto the concrete, and he was obviously dead, but Mr. Jones proceeded to run him over again and again and again. And Mr. Jones says, I only hit him one time. I just hit him once. I don't even see how he could have died because I only hit him one time. What does that mean for you as the evaluator? What that means for you is that you're going to talk to all the witnesses. You're going to read the police report. You're going to see if Mr. Jones has had this level of aggravated violence and intensity of his aggression in the past. So you as evaluator now, you're going to have to try to resolve those discrepancies in the reports, because that speaks to Mr. Jones' state of mind, what he did when he hit Mr. Smith. So if there are conflicting accounts like that, then it's going to become your job to try to resolve those. So I always like to start with the defendant with very open-ended questions and kind of have like a free-form narrative. Tell me your story, kind of like you would do with a therapy client in the clinical world. And, I try not to lead them. I try not to give them any clues about what's important to focus on at first. I try to just leave it very open-ended and see where they go and what they tell me. And then I begin to ask specific questions to get them to explain their circumstances and how they were functioning in the hours, days, weeks preceding the incident, leading up to the incident. Where'd they live? Who'd they live with? Turns out Mr. Jones lived in a tent in the woods. He was homeless. But then he went and stole someone's car. And that's the car that he used to run over Mr. Smith. How was he related to Mr. Smith? How were they getting along? So I'm asking Mr. Jones to kind of go through all his behaviors. What did you do the day before the incident? What did you do the day of the incident? And so now I'm starting to tailor the questioning to him and provide a lot more structure to my questions and narrow them down and probing him for more relevant details. I'm trying to fill in all the gaps and inconsistencies and anything we might not know that might help us kind of get to resolve the discrepancy in the various accounts of what happened. And I want to know specifically about Mr. Jones' thoughts, feelings, motivations, and behaviors at the time of the incident. Did he think at that time that his behavior would be considered illegal or wrong? Did he think it was justified? And if he did, why? What was he thinking at the time that would justify his behavior? Can he verbalize a rationale for engaging in the behavior? And let's say that Mr. Jones says, well, I knew it was wrong to hit Mr. Smith with the car, but I was very angry because he stole something out of my tent yesterday. So I was going to make him pay for that, and I hit him with the car anyway, even though I knew it was wrong. Doesn't mean that we're finished and we know everything as the evaluator, because it doesn't prove that he knew it was wrong, because he's a psychotic individual. So just because he says he knew it was wrong doesn't mean he really did, because many defendants have confused recollections about their thoughts and feelings that they might have been having at the time of the offense. So as the evaluator, we want to seek other data to see if his account, even of his own mental state, is consistent or inconsistent with other things that he asserts during the interview and with what other people say, third parties. And what is Mr. Jones' current understanding of wrongfulness? Does he realize, like, now that the behavior was wrong, but at the time he thought it was okay? Because remember, at the time, he told us that he was having a command hallucination from God, that Mr. Smith deserved to die for his sins. So maybe he was more impaired then, but now he realizes that that was wrong and that that was a hallucination now that he's back on his medicine. So we have to seek out more and more data to support or disconfirm that possibility, right? Is there evidence that Mr. Jones' mental status has improved or that his criminal behavior is something that typically only happens when he's not functionally stable? And what about that volitional prong? We can't forget about the volitional prong. What about choice, planning, worrying about getting caught? Did Mr. Jones consider any alternative courses of action? Why didn't he choose them? Did he feel that running Mr. Smith over with the car was the only possibility, the only choice he had? How long before he ran Mr. Smith over with the car was he thinking about doing that? Did he consider how to get away from the police? Did he go hide? Did he run? In fact, he just sat in the car and waited till they got there. What does that tell us? And so there's, what would you have done, right? What would you have done? What would Mr. Jones have done if a policeman was already standing there at that intersection where he hit Mr. Smith with the car? If there was a police officer there looking right at him, would he still have committed that act? Did he have the ability to control and delay his behavior? Did he understand that the behavior was illegal? And sometimes defendants are not really able to accurately explain why they behaved a certain way, because they're being asked in their present mental state, like now Mr. Jones is back on medicine, antipsychotic medicine. So he's being asked to figure out now that he isn't having hallucinations or delusions and he's back on his medicine, how he reacted when his mental status was totally different. So we have to think about that too. So we're thinking about his behavior, his demeanor. Is he cooperating with us? Is he guarded? Is he calm? Does he pace the room during the interview, is he oriented? Does he know who he is, where he is, what time it is? Can he pay attention and focus on our conversation? Does he have a good memory? Does he remember the time period around the offense? Does he seem depressed? Does he seem manic? Has he been sleeping? Has he been eating? What's his energy level? Does he have a range of affect, or does he have a very flat affect? Does he still have delusions or hallucinations? How's his communication, his thought process? How's his insight? Does he recognize that he has symptoms of a mental illness? Does he acknowledge his previous impairments? Does he know what's proper socially? And what about his medicines? How do those affect his mental status, positive or negative? You know, does Mr. Jones paranoid schizophrenia, does that impair his ability to present an accurate account of what happened? Let's see, what else? How about structured data? That's the last part. We talk about structured data. So Rogers Criminal Responsibility Assessment Scales, that's very widely used. So in Mr. Jones's case, I would select the Rogers Criminal Responsibility Assessment Scales for certain. I would definitely test him for cognitive deficits. He did attend special education when he was in school, so I want to know how that contributes. And then I want to know all about his psychopathology, so I'm going to give the MMPI, and I'm going to give the PAI, Personality Assessment Inventory, and those are going to help me measure the psychological constructs that are relevant to the legal issues in this case. So those are going to give me a good look at Mr. Jones' symptoms of schizophrenia and any other mental health symptoms that he might have. And then that is going to be added in. The results of those assessments will be added in as another data point from which I can generate hypotheses about Mr. Jones' clinical status. So don't think that we're measuring his legal insanity. That's not what we're doing. We're measuring psychological constructs that are going to help us have another data point to confirm or disconfirm his state of mind. But those things are going to reflect his presentation when we administer them. So his MMPI and his PAI, that's going to tell us now, today, when he takes those assessments. And from those, we can generate a lot of hypotheses about his diagnosis and about maybe long-standing personality traits that he has that are there in addition to his clinical diagnosis. So how do we pick the test? The test has to be relevant to some element that impacts criminal responsibility, the issue of Mr. Jones' criminal responsibility. The test has to be reliable and valid, and it has to be appropriate for the population that is applicable to the defendant. So this test needs to have been normed on people that have paranoid schizophrenia, that are in Mr. Jones' age group, that are the same gender, and it needs to be relevant to his criminal responsibility. So will the test help rule in or out a specific type of impairment that could impact Mr. Jones' cognitive or volitional capacity relevant to the insanity standard? So yes, because the MMPI and the PAI can help corroborate that he does have symptoms of paranoid schizophrenia. What's the error rate of those tests? Do our peers generally accept them as a good measure of paranoid schizophrenia? Are they validated on the population Mr. Jones comes from? Mr. Jones is African American. Have these tests been validated on African Americans? Will these tests give us some clues about his response style, whether he over-reports or under-reports symptoms? And so that's why I like the MMPI and the PAI, because they both do that. Another one I might pick is structured interview of reported symptoms. That assesses different malingering strategies, like does the person report rare symptoms? Do they report certain combinations of symptoms, observed symptoms? So that is validated on forensic and correctional populations. There's also the Miller Forensic Assessment of Symptoms test and the structured interview of malingered symptomology, validity indicator profile, and test of memory malingering. Those are some others that I might add into Mr. Jones' evaluation. Okay, so we finished the evaluation and I'm packing my stuff up and Mr. Jones says, how'd I do? How'd I do on that test? What does the standard say about what we can tell him? Well, there's not really a standard for that. You kind of have to determine on a case-by-case basis about providing feedback to the defendant about the test results. So what I tell Mr. Jones at this time is that I have to have time to review all the data and that we can have another chat later after I've done that. Because what I want to do is I might loop back around with him for one more interview and see if he kind of gives me the same story again. And after I've talked to a lot of other sources and reviewed everything, I might see what he has to say if I confront him about a few discrepancies in that second interview. And let's see if he tries to come up with any plausible sounding explanations for those discrepancies, or if he creates more inconsistencies. Maybe he'll say, I'm really ashamed my schizophrenia made me do that. And I didn't really report all my symptoms to you, their true severity. So we'll see. So it may happen that the data is not clear and that I have to consider a bunch of different explanations for Mr. Jones' behaviors. And I may be going to have to pick the explanation that's a best fit for the data about Mr. Jones, and then acknowledge the alternative explanations also. So a lot of times the direct information from the defendant, what Mr. Jones directly tells me, that's going to help me get a good initial hypothesis. And then I can corroborate or disconfirm that with additional data sources. I can determine the validity of Mr. Jones' presentation, of his clinical status, is his reported mental state at the time he hit Mr. Smith with the car consistent with the known elements about paranoid schizophrenia and his behavior and external observations of his behavior. What is the relationship between the clinical symptoms that Mr. Jones exhibited at the time that he hit Mr. Smith with the car and that specific behavior that he did? And this is going to have some implications for the decision about his abilities relative to the cognitive and volitional prongs. How was his ability related to the cognitive and volitional prongs impacted by his paranoid schizophrenia? Now, as the forensic evaluator, I cannot presume that because Mr. Jones was experiencing a command hallucination at the time of the defense, that his paranoid schizophrenia and that command hallucination is the primary cause of his behavior and the primary reason why he ran Mr. Smith over with the car. I have to try to validate the data through all these collateral sources. I have to speak to everyone involved. I have to read all the records. I have to seek out contradictory data. And I don't want to reach for conclusions. I don't want to have to stretch myself to come to a conclusion. I want to base the conclusion on the data at hand and fully articulate a connection between the data and my conclusion. So I have to be guided by the statutes and the case law. It all loops back around to that. So when I write my report, I'm going to write it for the lay reader. It's not going to be full of a lot of technical jargon. I want everything in it to be relevant, clear, and I want it to be a full and complete picture. If I use technical terms, I'm going to define them. I'm going to document all my sources of data. I'm going to articulate a relationship between the data and any conclusion or opinion I put forth. Basically, my report should be an outline for my future expert testimony. And I should assume when I write the report that I'm going to give future expert testimony. And the report is my preparation. It's my study guide. I like to separate my reports into distinct sections where they're clear and organized. The data is clear and organized. So I'll start with like the identifying information. Who is the defendant? What kind of charges does he face? Where did this referral come from? What's the main issue of the referral? What's the date that the alleged offense happened? Where did I get all my sources of information? The clinical interview, all the documents I reviewed, all the records I reviewed, all the collateral sources that I contacted, and the dates and the times that I spoke with them, and how long I spoke with them, all the tests I administered. Then I always put in a notification of the limits of confidentiality and privilege. What is my role as the evaluator? What's the purpose of the evaluation? What are the limits of confidentiality? Did Mr. Jones understand those limits when I explained them to him? Also put in there that I discussed the limits of confidentiality with all of the collateral contacts that I interviewed. And I informed them of the purpose of the questions that I asked and the limits of their confidentiality. I'm going to cite verbatim the legal standard in that jurisdiction that I'm working in and the source of that definition in the case law. I'm going to summarize all of Mr. Jones' past treatment, how he responded to that treatment. I'm going to summarize his criminal history, his mental status, and his clinical functioning, the results of medical tests he had, psychological tests, the state's version of the alleged offense, other persons' descriptions of Mr. Jones and the alleged events, and what is Mr. Jones' version of the alleged offense. And then at the end, I'm going to have my clinical opinions relevant to the issue of criminal responsibility. And that's all I have for you today.
Oh, Dr. Saar, thank you so much. What a complicated topic, and yet you gave us so many wonderful examples and how to think through this, how to write up your report, the sections of the report. What a very, very comprehensive lecture. Thank you so much for your time here today.
I'm so glad I could do it. It was fun.